Good afternoon, everyone, and welcome back to another episode of Speaking Legally, where the legal meets the cultural. This is your go-to show for information with our two legal experts, provided to you by Destiny Designers TV Network, and I am joined by Edward Pichardo, Esquire, and Royce Russell, Esquire. I'll let them greet you. We know it's been a lot, as usual, going on in the news. We thank you for constantly tuning in, being here, putting your posts on the show, letting us know what you are gaining is by way of knowledge every time that we share with you, and also sharing the broadcast out with those that follow you on your various social media outlets. So, Mr. Russell, great to have you back with us. How are you, sir?
Great to be back. You know, everybody needs a moment to recalibrate, and it's dangerous times out here when you're trying to fight this revolution. So, you know, those who are prepared, stay prepared. So I'm prepared. So let's get it rocking. Hey, brother Machado, how are you?
Hey, welcome back, my brother. And as they say, or don't say, in this case, the revolution will be televised, right?
Yeah, as long as we have Dr. Stacey Grant on our side.
Okay. Pues mira, hola, buena tarde. Hello, good afternoon to everyone in the audience. I think you're going to find this show very fulfilling, educational, and spiritually strengthening. Okay, so I think you're gonna like this show right here for sure.
Well, I mean, clearly we're talking about what's happening hot in the news, and telephone conversations. We texted a little bit last week, another situation, but now this one where the cultural meets the legal, where the legal meets the cultural. What is really going on in the world when we're hearing about a certain set of private phone calls between New York City jail inmates and legal advisors wrongly recorded? What is this about?
Well, I'm going to tell you what it's not. Go ahead, Royce.
No. What I was going to say is that, for those who are faithful watchers and listeners of our show, once again, we had no idea this article would be floating around when we talked about consent, or when Brother Pichardo talked about consent, and at least in New York, that only one party needs to give consent in order for a conversation to be recorded. And that is important because not only today, Brother Pichardo, as you know, we've had someone come in for a consultation that said, I have everything recorded. Everything is recorded. And that was that person's go-to piece of information as to evidence as to why things went wrong. Forget the fact that there was other factors as to what went wrong, but the fact that they had the recording. And so we see the life of recordings taking a life of their own. And we're seeing it not only in criminal matters and family court matters, but we're seeing it in employment matters when it's time for someone to be terminated. We're seeing it not only in the quote unquote gossip town of the projects, let's just say, or in the neighborhood. We're seeing it used in corporate America to substantiate claims, whether it's against a celebrity or whether it's against someone that is, that is unknown. So this is a very, very big thing. And I think it's here to stay. And it varies from state to state. So you take that and now you extrapolate that to what we now see right in front of us, over 1,500 private phone calls between New York City jail inmates and legal advisors wrongfully recorded. That's what the audit shows. So there was times when there was no audit. What does that show?
Listen, right here, when I saw this article, I thought about that song "Telephone Love," and I said, "This is not it right here." I said, "This is horrible. This is a constitutional right for you to be able to speak and confer with your counsel in private. It is supposed to be a privileged communication, and here you have Securus Technologies, one of the behemoths in the communications industry, and almost has a monopoly in all sorts of correctional setting communication systems, allowing for the recording of these phone calls between lawyers and their clients who happen to be incarcerated. And I'm thinking, whenever you are charged with a crime, and on top of that, you are incarcerated, you're in custody, you are particularly vulnerable. And so now you also have to face the possibility of having your communication with your lawyer recorded. Not to mention the fact that...
let me interrupt so just the audience can really understand this. It is like not necessarily what you're saying, because I understand what you're saying, so you don't need any interpreter, but understand what Securus is. Securus is like Otis elevators.
Exactly.
I don't know any elevator that I've gotten on that wasn't Otis, right? I mean, that's how well known it is. So one would say, or at least I would say, whenever a company has a monopoly on an industry, you have things like this that happens that make you say, whoa, that make you feel alarmed as we see the responses, because there's no checks and balances. Now, if there was more competition in this area, if it wasn't my cousin Vinny who has the contracts from state to state, because once you get one contract and you able to manage one facility, you become the first place kind of business. You're the first one to come out. You're in first place. You're ahead of the game. Your marketing is ahead of the game. You have the procedures, the protocol of how you're going to put things in place. So someone else bidding for those contracts will probably lose out. So Securus is the go-to company, and pretty much will always be, despite the audits. Continue, brother.
Well, Securus Technologies, it's a Texas-based company. And what people have to understand here is that, you're dealing with two legal issues right here. You have this latest incident where it has been discovered that at least, and I say at least only because I think we're only scratching the surface here. I really do believe that many more than 1,500 calls were illegally recorded. And the problem is that my understanding is not only were they recorded, but they were then sent to the district attorney's office, because the district attorney's office routinely will issue subpoenas to corrections, to say Securus Technologies, who handles the communications, to get those phone calls. And what I'm talking about is their subpoena is asking for the calls that are non-attorney calls, your basic calls, period. And see, this is important because this dovetails off of what we talked about last week. Many people may not know that when you call a relative who is incarcerated, or they call you and you speak to them, that phone call, because of the setting, does not enjoy an expectation of privacy and is recorded, and the district attorney's office will listen to that call to see if any incriminating information or information of any new crimes is communicated on that during that recording. And so what happens is now you have, they're claiming that this was some sort of technological error, that the attorneys who were on these calls with their clients should have heard some sort of ping or message saying that the message was being recorded. But the problem is that under the Sixth Amendment and the Federal Wiretap Act, you're not even supposed to be monitoring or recording these calls in the first place. So,
there's two avenues to that, right? The first avenue is the family, right? So we just stay going uptown. So let's say we're going uptown, we're going to go with the family, right? You always tell your clients you have to listen to what is said on the phone, right? And what usually is said on the phone is this phone call is being recorded.
Exactly.
You can't be so anxious that you want to speak to a family member that you don't listen to that part. So there is an obligation on the cultural side or the family side to recognize that. As I advise clients all the time, don't talk on the phone about your case. There's nothing that you're going to be able to tell anybody on the outside that's going to make an ounce of difference if I don't know it. And if I know it, there's no need to repeat it. And you have to be mindful of who you talk to, because people are reckless. People on the other end say what they want to say when they want to say it. Like you ask someone, hey man, what's going on around the neighborhood? And somebody says, yo, the block is too hot, man. Since you left, we did A, B, and C, D. What do you mean since I left, we did A, B, C, and D? Wait a minute, bro. You're like, so I wasn't talking about my case. I asked a general question. And now my man who's trying to make sure that I'm down, make sure that I didn't miss that Sunday came, that the sun came up, at 7 o'clock, want to make sure that I get that piece of information, is now talking about, hey, when you left, this is how it was. And now that you're gone, when you hear it was A, now you're gone is B. I don't need to know all that information, right? Because they're just trying to be who they're trying to be because they're not behind bars. That's one. Two is what we are up in arms about as attorneys. Once again, we should know better that the government is always listening. The state is always listening. The issue becomes, one, can they use that against you at trial? And two, they should have to play by the rules. And they're not playing by the rules. And securists don't give a damn because they don't know the inmate personally. And as far as they're concerned, what's the penalty? What's the penalty? Get a $3 million contract from Mayor de Blasio? What's the penalty?
Well, that's what that it's interesting that you mentioned that because you started this off by talking about them being like Otis elevators, right? And so what we're dealing with is this huge conglomerate that is able to withstand lawsuit after lawsuit. They have been sued in Texas, for instance. It was 14,000 calls, not 1,500. They've been sued in Kansas, in California. And I believe some of those cases are pending. You got, other lawsuits concerning the excessive fees that they charge inmates and their families for these calls. And there've been a number of states with that, including Maine and I believe Oklahoma. I mean, they've been sued all over the place and they seem to continue to engage in pretty much the same conduct because, hey, listen, companies like this, they hire large law firms, they litigate the hell out of these cases, and in the end, they quietly settle them, So
here's a scenario, Ed, in what you're saying. Here's a scenario. So, or the reality, the majority of folks that are in jail, I may be making an assumption, but I think my assumption is right, are underserved and underfinanced. Exactly. While you're in jail, you are worked and not paid any legal wage to produce products for America. So let's don't forget that it's free labor. We can go back to the history of slavery and prisons and free labor. It hasn't changed. And then you're being extorted by the prices of securists as to telephone fees. Now, we know in New York, they got the no free dial, right? Mayor de Blasio was able to do that and cut a deal with them, right? But now you're extorting them in order, them being inmates, to speak to their family members. So they walked in with no money because the folks that commit money crimes, they're in federal prison. That's a whole nother situation, right? Because this report is about Rikers. This report is about state. This report is not about the feds, right? So the underprivileged and underfinanced and underserved are in state jails. They are being used as far as labor, and they're being financed and out the yin yang as far as what they have to do in reference to paying for these phone calls. They might be extorted while they're in jail for phone time, right? And only thing Securus has to do is say, my bad. That's it. So, because what's the financial penalty, right? What's the dollar amount on having your phone call recorded, turned over to the DA, but maybe the DA didn't use it at trial, or maybe
and I think you bring up an interesting point because I believe that now the district attorney is saying, listen, maybe we did get this recording, but we certainly didn't listen to it once we realized it was a communication between the lawyer and the otherwise defendant, and so we didn't even listen to it.
And that's
the problem
crazy. That's crazy because when I call my clients, I don't ever, there's no exchange that says attorney this, attorney that. I go, hey man, what's up, man? How's everything? What's going on? We get straight to the mustard, right? So what the DA could be saying is that they don't find out that you're an attorney until the end of the conversation when your client is saying, all right, Mr. Russell, I'll see you in court. Then you're like, oh shit, that was an attorney-client conversation. We heard all of that. And once the bell is rung, you can't.
We're not believing that. I mean, who am I to say I'm not believing? It just sounds a little suspicious that, you're not going to listen when you have access. But I want to pause and say, hey, Monica, hey, Jason, hey, Richard. Thank you all for tuning in as usual and being here. But this really gives us pause. And it also looks at some of the other issues that we've talked about before. Who's controlling what? How do these people get the contracts? If there is no financial penalty, it's, I'm sorry, my bad. And, you move on. So how do we effectuate change, which is really what needs to happen? Because I'm sure this is not the first time. And Senor Pichardo, you already told us about these other states that had similar issues.
Well, let me just be clear. When the New York City Council passed their law in August of 2018, it was basically to remove the city's profit out of it. What they basically said that we're going to provide free phone calls and we're not going to receive any revenue from those calls, because prior to that, they used to get a cut.
Wait a minute. I thought all this was about the rehabilitation of the family and unification of the family and making sure that inmates stay connected. And if you're charging them a price to make this phone call, how can they stay connected? Because prison is rehabilitation.
Well, they did both. They said, we're going to provide no fee calls and we're not going to take any revenue from those calls. Because before that, yes, they used to be a charge plus they used to get revenue from it too. And this continues in other places where Securus has the contract, they get their money and they give a cut to the governmental entity that they're contracting with, the correctional entity that they're contracting with. So that's what makes this so insidious. And on the federal level, there was a FCC regulation that capped the amount that could be charged. But I believe that in the 10th Circuit Court of Appeals, the court there said, I think it was a decision of 2-1, that the FCC could not regulate intrastate calls. So some families have gone to the point of getting an out of state phone number to call from, to then be able to say, nah, that has to be capped at a certain price. Because right now, nationally, state by state, the price of these calls are crazy. And, you got this mixed with private prisons, right? You got private correctional facilities that are owned by companies. You got inmates getting gouged for the cost of the calls. And my understanding is about a year ago, I think I saw something, or I read something, where there's also an issue of the issuance of some sort of tablets that they charge you for also, in terms of any emails or written communication. So trust me, this is this right here. I'm hoping that this story right here sheds some light on the extreme exploitation that takes place of poor people, and in particular poor people who are incarcerated. Because I remember one time having to visit a relative who was in prison upstate New York, and I couldn't believe the amount of hours that you had to ride that bus to get up there. And I started thinking to myself, what about all these other families who make these journeys, these treks to see their loved ones, and how much it costs, and all of those things that go along with it. So, people really need to start examining this space beyond some of the surface stuff and get into the nitty gritty of what is really happening here,
And when you look at that in the context of my rights have been violated, and now what can I do? And how can I be compensated? And so this is analogous to sometimes when hospitals inadvertently violate HIPAA laws, which releases your medical information. Come to find out, when you try to litigate that,
No private right of action. Yeah.
There really isn't any compensation to that. What happens is the hospital might get fined, they may get admonished, but there's no pot of gold at the end of litigating that. And so when you say my rights have been violated in reference to speaking to my attorney, there is liability. And then there is, well, what is the damage that was done based upon liability? And that's why you haven't seen lawsuits of this nature come out. One is because it's been hidden, but two, a lawyer can say, all right, yeah, you were damaged, that Securus and the state is liable, but how were you damaged? None of the information is used at trial, quote unquote. You may have taken a plea. If this information that they had, they sure didn't show their hand. So how do we put an economic number on it? And so what happens is that it goes unguarded, it goes untested, it goes unlitigated, and we move on. And maybe an expose like this comes out, and next thing you know, we're talking about the governor being impeached, or we're talking about the George Floyd trial, and life goes on. And attorneys are protected in that they know whether or not you're listening or not listening, you can't use it. It might be bad for their reputation because they might be calling assistant U.S. attorney or a DA some very choice words, or they may be manipulating the positioning that the U.S. attorney or the district attorney has on the client to start getting the client to think about something different. So therefore, when you say my client is not going to take 7 years, and they're like, well, shit, I heard that phone call. That phone call between him and Mr. Russell said, man, give me anything. I just need to get this off my back.
And I think that's what I'm thinking. I'm thinking if you're able to possibly make a link between something you said during your call with that client and the outcome of your case, I think it may be worth.
How do you prove it?
Oh man, I mean that's the problem. Yeah,
as lawyers, we know this, and Dr. Grant, as a layperson, whether by way of her own experience or just life experience, yes, there is a wrong. How do you prove it? How do you go about proving that it's a wrong? It's tight.
It's tight, but I think that something has to be done because the attorney-client privilege is one of the most sacred tenets of law, and especially criminal law, for you to be able to confer confidentially with your client. And the minute that is breached in this way, and you can't even begin to prove or say whether or not it was used or not, I think the use part of it is problematic for me in terms of the legal analysis, because it should be presumed. It should be presumed that it was somehow used detrimentally against your client, because it shouldn't have occurred in the first place.
Well, I get that 100%. And we all see the movies where, I remember an episode of Empire, right? The little kid who's now a gunner now. I don't know what his name is. He's a gunner now. He's the big shot. Anybody remember his name? He's what's the face son? What's the guy's name? He's his son. Now he's around shooting everybody. But he was forced to get on the stand to testify against his mother, and the lawyer was outside the building. He said, "Give me $1." He gave the lawyer $1. And he's like, all right, now I'm retained. So now you can talk to me about anything. Right? We think it's that simple. It's not that simple, right?
It's not that simple. And some of us don't watch TV like that. So we didn't see the Empire episode. But
you'd be surprised.
Well, you know what's amazing? I was reading about Robert Kardashian the other day, and I was reading something very interesting. They say that the only reason he ended up renewing or reactivating his law license because it was inactive at the time that OJ came to his house and all that, and everything, and while everything was going on, and the reason why he reactivated his license and joined the defense team so that they wouldn't be able to question him on the stand about his communications with OJ.
That was smart.
Because now it was subject to attorney-client privilege. So, this has a lot of interesting facets and dynamics to it, for sure.
It does. And we have a question from Rolanda. How are you, dear? Does documenting your conversation help? So before you answer that question, let's just also, as we start to move into the next part of our discussion today, look at what we need to look at. Who's running these programs, services, privatized prisons, those who are state? How do they get these contracts? I mean, because clearly it's going unchecked. There's no regulatory agency that's monitoring how these particular companies do their business. So there's opportunity for folks who are on the ground working on reform, looking at all the different parts of the system that is not working. This is one that some light needs to be shined on. But let's answer the question.
You want to answer that question, Royce?
Sure. I mean, can document help? Yes. It can help in that. Well, let me backtrack. I would say yes and no. Yes is that you always want to know when you were talking to your attorney, just in case something comes out of it. But I think in reality, no, it really doesn't help, because unless the DA shows their hand that they have inside information, you'll never know. So in my brain, the assumption is that they're always listening. Period. That's it. They listen all day, every night. And so you have to say to yourself, have at it. I'm not saying anything that is going to be to my demise. Because if you document and you say, yes, I was on the phone with my lawyer at 7 p.m. on October 13th, when that lawyer is having those discussions and negotiation 3 years, 2 years, 6 months after that phone call, banging on the desk saying, my client will take no more than 3 years, that's it. And the DA says, all right, well, we go to trial. Why is the DA being so cavalier? Because they heard that conversation that says, Mr. Russell, I don't want to go to trial. Do the best you can for me. All right, I'm going to bluff it out. I'm going to try to manipulate it so I can get this type of exposure for you, minimize your exposure and your damage. But how do you know that they heard that phone call? You'll never know.
And that's why I say that the presumption should be that if that information was turned over to the prosecutor and it came into their possession, that should be it right there. There should be a presumption that they listened to that conversation, and that, at that point, if anything in there was revealed that possibly could assist to aid them, that case, that.
But how do we get to that, Ed? So that means Securus would have to give that information over to us, over to us, the defense counsels, because you can't give it to the prosecutor, because the prosecutor is going to knock that right off. I mean, if they're unscrupulous enough to listen to the conversation, they're going to knock that name right off. And the judge does an in-camera inspection. Well, what was the conversation? What day did it happen? Then the judge has to make an inference that they did hear it, and that's it.
Yeah, and all I'm saying basically is that, it needs to be rigorously reviewed, legally analyzed. Like you said, they need to do an audit here in New York City of every single one of those 1,500 calls, the contents of those calls, and whether any of that information was information that possibly was used or could have been used against the defendant, and then look at the legal effect, and try to come up with some sort of remedy that provides justice to that defendant. That's all I'm saying. That a special set of judges, be assigned to review these cases, because it just. This is not something that should be taken lightly at all. I mean, what's happening right now is that technology and the expediency of technology is being used to trample over people's rights, and it's just simply not fair. And something needs to happen here. And especially since New York is one of the most forward-thinking states in the country, it should be looking to become the lead on this, given the fact that this is happening throughout the entire country. There are many states and other jurisdictions that could care less, because they care less about poor people and much less incarcerated poor people. And so, they're not going to do much about it. But, here we need to really take this seriously because, it shouldn't be happening in the first place. And in terms of our legislators, we need to really start looking at the procurement and the contracting of these services to this company, because it's clearly a company that's not responsible. It was not too long ago that New York State had private prisons, and I believe those were eliminated. And that was because, people started looking at that issue and saying, wait a minute, this is New York. Maybe somewhere else this is allowed, but not here.
Well, I guess we go back to what Dr. Grant, you talked about opportunity, right? Who's getting what contract? Where's the spinoff on all this? Where if the state is giving out contracts, there's supposed to be a spinoff that goes to minority vendors. I haven't heard any minority vendor even involved in any of this communication that we're talking about. And maybe that's an opportunity for somebody who's listening out there to get their ducks in a row to say, hey, I want to come in. I want to join in. I want to stand for, doing it the right way. And I should have some of this contract work here.
Absolutely. That continues on a whole nother show conversation about access and opportunity and what real reform looks like. So to be continued, but I'm glad that we brought it up on the show, because if you don't have someone who has been touched by the criminal justice system, this might seem like, oh, what's the big deal? But if you do know someone and you have family members that have been touched by the criminal justice system, you know what a breach this is. It's a violation. A violation is a violation, and it's seemingly going to just go away with, oh, wow, that's unfortunate. Oh, sorry, we made a mistake, but trust and believe it wasn't you. So, more to be discussed on this. We're bringing it up now. We hope someone picks up what Attorney Pichardo was putting down, so that you can really look at the opportunities that are available, as Mr. Russell just said, because something has to be done. It's not the first time something has happened, and it won't be the last time unless something is changed. So that's the morals of this story. But as we continue, our show is full with other news that's happening, and we know that everyone is watching right now. We started covering this in the heat of what was happening last year with the murder of George Floyd. And now that the jury has been, finally chosen, and, there is some interesting developments that we want you to make sure you backtrack from season 1 to watch how things are unfolding. And I think there's a certain makeup of this jury that we might touch on today. So I'm going to kick it back over to you, Attorney Pichardo.
Okay, well, it's been an interesting couple of weeks watching the Derek Charvin trial unfold in the murder of George Floyd. There were a number of maneuvers that were made by the defense to try to delay this trial. There were a number of issues that came up. One of the first issues that came up was the issue of whether or not to include a charge that had previously been removed by the judge, or otherwise the prosecution was told that they could not charge that charge, and that went to the Court of Appeals in the state of Minnesota, and that charge was reinstated. And then later on, the defense asked for a change of venue, I believe, because of the $27 million settlement that was given to the family for the murder of Mr. Floyd. I believe that was denied. He was claiming that when the jurors hear about this payout, they're going to automatically say, oh, well, his client must be guilty. That didn't happen in terms of the change of venue. And then, one of the latest issues, which is really disturbing is, and it's kind of a two-edged sword, is that the defense asked to be allowed to introduce video of a previous arrest of George Floyd by Minnesota police, not the same officers, but different officers, and the video of him being handcuffed, placed in the vehicle. If I recall the video, it showed him having kind of like a bit of a emotional breakdown, in terms of some crying and so forth, and then it shows him then in the station, behaving a little more calmly. So how this is probative beats me. I really think it should not be allowed into the case. I don't think it's relevant. Some people may argue possibly prejudicial. Others may argue that the prosecution will be able to use it to say, look, he was arrested without incident. Those officers didn't feel the need to put him on the ground and put their knee on his back, or on his neck rather, and suffocate the life out of him. What say you? What say you, Royce, on this matter?
Well, one of the things I look at, you mentioned the word probative versus prejudicial. And so for those that are not in the legal arena, those are very, very important terms. So probative means that it has some value. There's something that the jury can take in based upon what they can see. And we'll do that analysis based upon some of the things that you just said. Prejudicial is exactly what it is that the information is so one-sided, is so lopsided that it will force a juror to think a certain way. Forget a juror, a person to think a certain way that they can't rebound from. So let's pin that for 1 second. Let me go back to some of the other things that you said in reference to the third-degree charge, which was reinstated. Very important because it talks about unintentional. And I think it's important to understand that although a lot of people may in their hearts and in their mind think that this defendant, because I'm going to call him defendant, like they call people of color defendant. I'm not going to call him his name. This defendant maybe did not have the intentions when he left his home. But at the end of the day, Mr. Floyd died. So that third degree speaks to unintentional actions. And that's important because the jury could walk away and say, you know what, he didn't intend to do it. And then now they're stuck. So you want them to have as many options as possible to come back with a verdict that is, in alliance with what took place, or is reasonable, is not repugnant, right? Then we look at the whole change of venue. A day late and a dollar short, right? There's no place that you go to be sacred. Everyone knows about this. Social media, the life that we live, the light on social injustice, unrest, the basically one-sidedness or tip scales as to the legal system when it comes down to people of color. Can't run, can't hide. You could try all day, can't run, can't hide. So if the protests, which included celebrities and everyone that you could possibly think of in the world, does not get you a change of venue, then you got to know that even though we look at defense counsel, we say, yeah, why are you doing this? You crazy. Like, what are you throwing up against the wall you think is going to stick? Defense counsel has an obligation to do that to preserve the defendant's right later on to bring up whatever issue. So in that same lane, they bring up the change of venue. Hopefully he knew that would not go over very well in reference to having a new place to try the case while we're in jury selection and why we have jurors picked, because a settlement of $27 million has already taken place. And to that point, here's the pros and cons. The pros, or at least the cons for defense counsel. Hey, $27 million must mean he's guilty. That's what defense counsel is going to say. Prosecutor is going to say, well, if that's the case, we shouldn't have the trial at all, because the fact that he was fired also triggers that he was guilty. But we still here. We still trying the case. So let's just forget the shenanigans and let's just try the case. And this judge has been very, 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 very good up to now in his analysis and preserving the record and dotting the I's and crossing the T's, such as bringing back jurors, 7 that was already seated, to see what the impact of this settlement would have. We could do another show that talks about whether or not it was appropriate to do it now, to have the politicians and the family to have this done now, because I don't think one went without the other. I think the politicians had to confer with the family to say, look, we want to air this now. We want to do this now. Or would it have been better to just have the settlement under a strict no tell call clause, non-disclosure. No one say anything until the trial is over. So this way they wouldn't be influenced one way or the other. But nonetheless, it happened. And so now we move on. So we have 15 jurors, one to be excused once opening statement happens, which I think is Monday. We have, I believe, 9 white, 3 African-American males, 1 African-American woman, and 2 of mixed race. I wonder what is the mix of the race, but here we are, and we're going to move on. And what is most difficult, what people don't understand about dealing in this case or picking a jury in this case, is that it has been proceeding as if it's a federal capital case, death penalty case, where there is a questionnaire. The jurors have to fill out that questionnaire, and you get a chance to ask the jurors about what they wrote. And I haven't seen defense counsel or the prosecutors do a very good job in taking what Dr. Grant wrote on their questionnaire, going through her questions and asking her things about what she wrote, and then going to Ed Pichardo when it's his turn to become a juror. What they do is they automatically go to his questions. And what they should do, both sides should be taking the questions from what Dr. Grant had to say and mixing them up and saying, well, you heard potential juror Grant. She said A, B, and C. How do you feel about that, Mr. Pichardo? Because if you just go by what's on the questionnaire, then you're losing the full flavor of the human experience. Because there may be something that Dr. Grant said that hits me, but you'll never know because you're going by the questionnaire. You got to mix it up. You got to, you can only do it with a juror that has been questioned. You can't do it with a juror that hasn't been questioned. So you take the last juror that you spoke to, potential juror, and you take some of the comments they said, and you use it as your platform for the next.
And it's amazing, and it's interesting you say that, Royce, because I think it speaks to. I think a lot of defense. I think a lot of trial attorneys kind of overlook voir dire, and they look at it as a minor part of the trial. And I used to whenever I did my trials, to me, I looked at voir dire as a major component of the trial because I felt like this is like my first introduction to these people who are going to be deciding my client's fate. And so I would pour a lot of energy into voir dire, not only just in terms of trying to select the jurors that would be most favorable to my client's case, but also, kind of, setting the stage for, the coming trial of the facts. So,
and not only that, you use other people to get points out for you without you being the bad guy, without you having to say, hey, I believe in X. What about you? You say, hey, Dr. Grant said A, B, and C. Now, it shows a humanistic side that you didn't forget about Dr. Grant. See, this is the thing. See, this is about being right. This is the cookies and the cookie crumbs, y'all. So go ahead, go get the biscuit and sop it up because this is all about the gravy right about now, right? This is the trick. This is the human side. I call it trick, but this is being you, right? Hey, Dr. Grant just left us. I want to bring Dr. Grant back in that room because Dr. Grant had a personality. Dr. Grant might have affected some of the other jurors. They may have created a bond when they're in the back talking. So it's not about me. It's about you guys. So let's talk about what Dr. Grant said. Yeah. Hey, Mr. Pichardo, Dr. Grant said, she knows about Black lives a little bit, a little something. How would you describe your experience with Black Lives Matter? Is it a little bit like she said, or is it something? Well, and then next thing you know, now you have built the bridge without you being up front, being the front guy, being an asshole, you know what I mean? And then you're able to reveal other stories based upon what other people say. I remember one time as a defense counsel, the guy said, yeah, well, you're going to have a hard time selling me. I'm not buying what you're selling. I said, I understand that. Mr. X. I went over to Mrs. Y. Mrs. Y, do you believe I'm selling something? Because he said, you're buying what I'm selling. So do you see any vacuums here? Do I have any encyclopedias? And, what am I selling? And then, now this guy is on, woo-hoo, he's fire now. but he's probably an asshole already in the back, already, right? And so there we go. So now other folks are like, yeah, that's that guy that was already in the back. Yeah, look at him. He's toasting him. And that's how you find out who knows what and when.
It sounds like you were able to elicit a response that possibly triggered a striking for cause. Because
without a question. But I never let him leave the room. And that doesn't right. He's always so now I'm like, hey guys.
So there's a question here for Maria. Who creates the questions on the questionnaires? That was a good question.
Yeah. The judge and the judge's law clerks. You might be in a position where the judge might ask you a couple of questions, but other than that, it's all in the back room. All in the back room. That's what the clerks get paid the big bucks. Sit back there. We're going to write some questions that if there's not a focus group, it's go back there and we're going to write these questions and then we're going to come out and we're going to figure this out.
Now I've done trials where, you know, you didn't have the questions already set forth and you had the freedom of
that's the best trial. That's the best way to be.
Yeah, I've always hated when I'm constricted to these questions. It's like, oh my gosh, this is so.
Because who's to say like a person that just called in, Maria? Who's to say that those are the appropriate questions?
Exactly.
I want to ask some other questions.
Mm-hmm.
Exactly.
But that's a good point there. As we are winding up today's conversation, there's a lot to watch here. I'm really curious to see how the breakdown of this jury plays out in the case. And, it's just another one of those high profile situations. I just want to ask both of you, should there be something particularly that we're watching for or we're listening for? This is where the legal meets the culture. So when you break down all of the legal jargon and procedures, what culturally should we be looking for? Because we know how this particular murder case is impacting us.
Well, I think what Roy said earlier was key when he talked about the reinstatement of that third degree charge and the unintentional element of it, because it may come down to a point where you can't get a unanimous verdict because some people may feel that, oh, well, I know it was bad, but he didn't intend it. I believe him when he said he didn't mean it and all this and that. And it may come down to that, in terms of what comes out. I know that I think about a month ago, an issue came up as to the exact time that the defendant was on the victim's neck, and that there was a difference in the time in terms of the exact video and what was being put out there in terms of the exact amount of minutes and the seconds and the connection of that to the intentionality of the actions of the defendant. So I think I'm going to be looking for that in terms of the trial, whether that becomes an issue.
What I'm going to be looking for is what I've already looked at, which is, and I'll say it just because I can, how dumb can you be in not having diversity in that courtroom? I looked at the teams. Maybe I'm mistaken, and if I am, I apologize. I don't see anybody of color, and I damn sure ain't see anybody of color take the mic. From the defense perspective, are you that arrogant, that self-secure, that you don't need anybody of color to be at your table, to be able to speak those words? Now, shame on you. Take it as it is. I'm going to keep on moving. As a prosecutor, are you that blinded that this is all about culture and color? That this would have never, in class, this would have never happened to anybody that is not Black and was not poor? Come on, guys. I've seen this movie and this script over and over and over and over. This is an indictment of the whole criminal justice system and the lack of diversity and the ability of those that are in power to see how diversity is important. And even if you want to be selfish, which is on the defense side, just win this case. Selfish. Get someone of color to be on your team. Prosecutor, if you want to win this case, have someone of color taking the lead. Selfish. But goddamn, be selfish. Because I'm looking at this and I'm saying to myself, I know I could have made that point. Like, little Ed, I know. I mean, like, I'm listening. I'm like, whoa, like, wait a minute. Like, bring it home. Where, bring it home. And if you don't start to bring it home now, well, you waiting for the crescendo down later, down, right? By then, you boring Ed all day. Now, on the last day, you're going to come in with your finest of clothes and your sharp tie, and you're going to speak words of wisdom. Like, where was this all before? And what I'm also looking for, because I don't know if it's too late to have somebody shift gears and appear and put in a notice of appearance as co-counsel on any side, is the defense looking to have the defendant go home? But is the defense looking to have the defendant convicted of one of the lesser included charges? And you'll be able to tell that through the questioning. I think going home in a home run is quite a swing. And what is the defense counsel doing to manage his client's expectation? Saying, hey, man, we might get a triple here, but I don't think you're going home. We might get a double here. Oh, that third degree charge that just came in now looks like a single, homeboy. Before it looked like we could slide. Now it looks like, because now they talk about unintentional and wait. Those are the conversations that need to be had, and it plays out through the questioning. So,
and it's amazing that you mentioned that, because in some of these police brutality, police caused death cases, I have sometimes seen, where some prosecutors' offices will overcharge, in my belief, with the intent of later on knowing that they're going to have a problem proving that very high charge. You know what I'm saying?
Right.
In terms of getting a unanimous verdict. And I've seen it. There have been times when I've said to myself, wow, I'm looking at those facts right there. Why are you charging a first degree intentional homicide when you know that more than likely than not, you're going to get a few jurors on that case? And the defense is going to be able to prove that, you're not going to be able to meet that burden right there, So it's going to be interesting.
It is, and we're going to be here going through it and highlighting what you've learned through season 1 and going into, believe it or not, this is the year we're coming on our anniversary of starting Speaking Legally, because this was happening in real time, and there's been so much that has transpired in a year. And our two experts, our legal experts, have been in here walking you through, explaining the law, so you don't have to make it up or listen to what I call the sidewalk attorneys. These are the two experts that do this day in and day out, and that you can stay connected with them at both of their websites, law office of edwardpichardo.com, RoyceRussellEsquire.com, and of course, get information and resources like cardiacarrestbook.net that can help you along your journey, navigate your touches with the criminal justice system. So after we get through the tough stuff, we always like to close out, and thank you, Maria, for tuning in, Jason, Richard, Jeffrey. We appreciate all of you. We also like to acknowledge different things culturally that happened, and we lost another legend in the sports arena. So we just want to close out today because we have some fans here on the show. So I'm going to turn it over to Attorney Russell, who is a Lakers fan. So go ahead and talk about our dearly departed.
Well, just before I talk about him, I just want to make sure that we also look for how that video plays out that you talked about, Ed. Like you said, the pros and cons. The pros are for the prosecutors that, look, Mr. Floyd made it home safely that night. The con is that he was arrested before. And so what? Who cares? He was arrested before. And that's not the issue. The issue is excessive force. So we need to see how that plays out. And talking about excessive force, Elgin Baylor had all the force and all the excessiveness and all the accessories ever. See them uniforms? They brought those uniforms back. I mean, he was so many players before these players even exist.
Yes, he was.
He changed everything. and he was a Laker, and that's my main man right there. There's so much that could be said about him. How many points he averaged during the year, second to none to Will Chamberlain. Probably was the reason why Will Chamberlain even came over to the Lakers in the first place. Some would argue that, Jerry West silhouette should not be that. It should be Elgin Baylor. No Elgin Baylor, no championship. That goes without saying.
Absolutely. I believe they brought Lakers their first championship because the Lakers were originally in Minnesota. That's why they called the Lakers.
That's right. And, when you talk about class, usually people tend to think about Julius Erving and how classy Julius is and was on the court. But that was Elgin Baylor, 86 years old, still icon with the Lakers, walking around, talking to folks, and just exhibiting class.
Now he was an executive with the Los Angeles Clippers for a number of years.
Yes, he was. Yeah. Yes, he was. A lot of folks go over to the other team. They go to JV. They go to JV before they come back up to Washington.
Well, listen, I don't understand how brothers from New York are fans of the LA Lakers either. I mean, you got to do the Knicks or the Nets, baby. Come on, man. That's
like you telling me that you are a Buffalo Bills fan in the same damn state. You ain't even never heard of no Buffalo Bills. Let me keep it moving. And I know you're a diehard underdog, so I know you're a Mets fan, right?
Oh boy!
I'm a fan of all New York teams. All right?
Yeah.
All New York teams.
All New York teams. Okay.
Well, listen. Since we're on sports, what's going on with Deshaun Watson? What's the deal here?
Here's the deal. This is where and let's put a pin in this. Let's tease it because we want to talk about it next week. Hella high water. Unless something else happens, we're going to hit this because you want to talk about cultural and legal.
Yeah, and activism.
Activism and racism. We want to talk about the elephant in the room, but yet we're not really talking about it. I think the blueprint, just for the couple of minutes that we have, the blueprint, unfortunately, has been laid out with Brother Bill Cosby, right? Right or wrong, whether they did or didn't, if you get enough people to say the same thing, and I've seen it in my own life as being a defense attorney. Come on, man. So-and-so said you robbed them. All right, that was a mistake. So-and-so said you robbed them. So-and-so said you robbed them. After you get to the 15 robbery, you're like, yo, it got to be you, right? All these things. But I cannot subscribe to that in this circumstance because there's so much behind door number one. So much. Just like with these telephone calls, right? Mr. Telephone Man, my line, my baby number. Okay. In return, what's that?
New edition, baby.
On my line right here.
My goodness.
Find out at some point what the real deal is, and just like we found out with New Edition with Mr. Telephone Man, and this story that just came out, we'll find out more next week. So
absolutely.
All right, family. Speaking legally, where the legal clearly meets the cultural. Thank you for tuning in, everybody. We'll see you next week, 4 p.m. Eastern Standard. Same time, same place. Bye-bye.
Oh.